217. Use of professional testing services. Notwithstanding any other provision of professional testing service to prepare, administer, grade, and evaluate any computerized examination, when that service is available and approved by the board, or the department when there is no board. 455.2175 penalty for theft or reproduction of an examination, in addition to or in lieu of any other discipline imposed pursuant to S. 455. 227. The theft of an examination in whole or in part, or the act of reproducing or copying any examination administered by the department, whether such examination is reproduced or copied in part or in whole, and by any means, constitutes a felony of the third degree, punishable as provided in S. 770 5.082, S. 770 5.083, or S. 775 4.084. And examination materials are confiscated is not permitted to take and not violate this section. Monitoring of compliance with continuing education requirements, with applicable continuing education requirements, and to determine each licensee's continuing education status. As used in this section, the term monitor means the act of determining, for each licensee, whether the licensee was in full compliance with applicable continuing education requirements as of the time of the licensee's license renewal. The department may refuse renewal of a licensee's license until the licensee has satisfied all applicable continuing education requirements. This subsection does not preclude the department or boards from imposing additional penalties pursuant to the Applicable Practice Act or rules adopted pursuant thereto. The department may waive the continuing education monitoring requirements of this section for any profession that demonstrates to the department that the monitoring system places an undue burden on the profession. The department shall waive the continuing education monitoring requirements of this section for any profession that has a program in place, which measures compliance with continuing education requirements through statistical sampling techniques or other methods, and can indicate that at least 95% of its licensees are in compliance. The department may adopt rules under SS 120.536 and 120.54 to implement this section. 455.2178. Each continuing education provider shall provide to the department such information regarding the continuing education status of licensees as the department determines is necessary to carry out its duties under S. 455.2177 in an electronic format determined by the department. After a licensee's completion of a course, the information must be submitted to the department electronically no later than 30 calendar days thereafter. However, the continuing education provider shall electronically report to the department completion of a licensee's course within 10 business days beginning on the 30th day before the renewal deadline or prior to the renewal date, whichever occurs sooner. The foregoing applies only if the profession has not been granted a waiver from the monitoring requirements under S. 455.2177. Upon the request of a licensee, the provider must also furnish to the department information regarding courses completed by the licensee. Each continuing education provider shall retain all records relating to a licensee's completion of continuing education courses for at least 4 years after completion of a course. A continuing education provider may not be approved, and the approval may not be renewed, unless the provider agrees in writing to provide such cooperation under this section and S. 455.2177 as the department deems necessary or appropriate. The department may fine, suspend, or revoke approval of any continuing education provider that fails to comply with his duties under this section. Such fine may not exceed $500 per violation. Investigations and prosecutions of a provider's failure to comply with his duties under this section shall be conducted pursuant to S. 455.225. For the purpose of determining which persons or entities must meet the reporting, record-keeping, and access provisions of this section, the board of any profession subject to this section or the department, if there is no board, shall, by rule, adopt the definition of the term continuing education provider applicable to the profession's continuing education requirements. The intent of the rule shall be to ensure that all records and information necessary to carry out the requirements of this section and S 455.2177 are maintained and transmitted accordingly, and to minimize disputes as to what person or entity is responsible for maintaining and reporting such records and information. The Department may adopt rules under SS 120.536 and 120.54 to implement this section. 455.2179 Continuing education provider and course approval cease and desist orders. If a board, or the department, if there is no board, requires completion of continuing education as a requirement for renewal of a license, the board, or the department, if there is no board, shall approve the providers and courses for the continuing education. Notwithstanding this subsection or any other provision of law, the department may approve continuing education providers or courses even if there is a board. If the department determines that an application for a continuing education provider or course requires expert review or should be denied, the department shall forward the application to the appropriate board for review and approval or denial. The approval of continuing education providers and courses must be for a specified period of time, not to exceed 4 years. An approval that does not include such a time limitation may remain in effect pursuant to the Applicable Practice Act or the rules adopted under the Applicable Practice Act. Notwithstanding this subsection or any other provision of law, only the department may determine the contents of any documents submitted for approval of a continuing education provider or course. The board, or the department if there is no board, shall issue an order requiring a person or entity to cease and desist from offering any continuing education programs for licensees, and fining, suspending, or revoking any approval of the provider previously granted by the board, or the department if there is no board, if the board, or the department if there is no board, determines that the person or entity failed to provide appropriate continuing education services that conform to approved course material. Such fine may not exceed $500 per violation. Investigations and prosecutions of a provider's failure to comply with his duties under this section shall be conducted. Under S 455.225, each board authorized to approve continuing education providers, or the department if there is no board, may establish, by rule, a fee not to exceed $250 for anyone seeking approval to provide continuing education courses, and may establish, by rule, a biennial fee not to exceed $250 for the renewal of providership of such courses. The Florida Real Estate Commission, authorized under the provisions of Chapter 475 to approve pre-licensure, pre-certification, and post-licensure education providers, may establish by rule an application fee not to exceed $250 for anyone seeking approval to offer pre-licensure, pre-certification, or post-licensure education courses, and may establish by rule a biennial fee not to exceed $250 for the renewal of such courses. Such post-licensure education courses are subject to the reporting, monitoring, and compliance provisions of this section and SS 455.2177 and 455.2178. The department and each affected board may adopt rules pursuant to SS 120.536 and 120.54 to implement the provisions of this section. 455.218 Foreign trained professionals, special examination and license provisions. When not otherwise provided by law, the department shall by rule provide procedures under which exiled professionals may be examined within each practice act. A person shall be eligible for such examination if the person immigrated to the United States after leaving the person's home country because of political reasons, provided such country is located in the Western Hemisphere and lacks diplomatic relations with the United States, applies to the department and submits a fee, was a Florida resident immediately preceding the person's application, demonstrates to the department, through submission of documentation verified by the applicant's respective professional association in exile, that the applicant was graduated with an appropriate professional or occupational degree from a college or university. However, the department may not require receipt of any documentation from the Republic of Cuba as a condition of eligibility under this section. Lawfully practiced the profession for at least 3 years prior to 1980, successfully completed an approved course of study pursuant to Chapters 74 to 105 and 75 to 177 Laws of Florida, and presents a certificate demonstrating the successful completion of a continuing education program which offers a course of study that will prepare the applicant for the examination offered under subsection. The department shall develop rules for the approval of such programs for its boards, upon request of a person who meets the requirements of subsection and submits an examination fee. The department, for its boards, shall provide a written practical examination that tests the person's current ability to practice the profession competently in accordance with the actual practice of the profession. Evidence of meeting the requirements of subsection shall be treated by the department as evidence of the applicant's preparation in the academic and pre-professional fundamentals necessary for successful professional practice, and the applicant shall not be examined by the department on such fundamentals. The fees charged for the examinations offered under subsection shall be established by the department for its boards by rule and shall be sufficient to develop or to contract for the development of the examination and its administration, grading, and grade reviews. The department shall examine any applicant who meets the requirements of subsections, and, upon passing the examination and the issuance of the license, a licensee is subject to the administrative requirements of this chapter and the respective practice act under which the license is issued. Each applicant so licensed is subject to all provisions of this chapter and the respective practice act under which the license was issued. Upon a request by an applicant otherwise qualified under this section, the examinations offered under subsection may be given in the applicant's native language, provided that any translation costs are borne by the applicant. The department, for its boards, shall not issue an initial license to or renew a license of any applicant or licensee who is under investigation or prosecution in any jurisdiction for an action which would constitute a violation of this chapter or the professional practice acts administered by the department and the boards until such time as the investigation or prosecution is complete, at which time the provisions of the professional practice acts shall apply. 455.2 185 Exemption for certain out-of-state or foreign professionals. Limited practice permitted. A professional of any other state or of any territory or other jurisdiction of the United States or of any other nation or foreign jurisdiction is exempt from the requirements of licensure under this chapter and the applicable Professional Practice Act under the agency with regulatory jurisdiction over the profession, if that profession is regulated in this state under the agency with regulatory jurisdiction over the profession, and if that person holds, if so required in the jurisdiction in which that person practices, an active license to practice that profession, engages in the active practice of that profession outside the state, is employed or designated in that professional capacity by a sports entity visiting the state for a specific sporting event. A professional's practice under this section is limited to the members, coaches, and staff of the team for which that professional is employed or designated, and to any animals used if the sporting event for which that professional is employed or designated involves animals. A professional practicing under authority of this section shall not have practice privileges in any licensed veterinary facility without the approval of that facility. 455.219 Fees, Receipts, Disposition, Periodic Management Reports. Each board within the department shall determine by rule the amount of license fees for its profession, based upon department-prepared long-range estimates of the revenue required to implement all provisions of law relating to the regulation of professions. By the department and any board, however, when the department has determined, based on the long-range estimates of such revenue, that a profession's trust fund monies are in excess of the amount required to cover the necessary functions of the board, or The department when there is no board. The department may adopt rules to implement a waiver of license renewal fees for that profession for a period not to exceed 2 years, as determined by the department. Each board, or the department when there is no board, shall ensure license fees are adequate to cover all anticipated costs and to maintain a reasonable cash balance, as determined by rule of the department, with advice of the applicable board, if sufficient action is not taken by a board within 1 year of notification by the department that license fees are projected to be inadequate, the department shall set license fees on behalf of the applicable board to cover anticipated costs and to maintain the required cash balance. The department shall include recommended fee cap increases in its annual report to the legislature. Further, it is legislative intent that no regulated profession operate with a negative cash balance. The department may provide by rule for the advancement of sufficient funds to any profession or the Florida Athletic Commission operating with a negative cash balance. Such advancement may be for a period not to exceed 2 consecutive years and shall require interest to be paid by the regulated profession. Interest shall be calculated at the current rate earned on professional regulation trust. Fund investments. Interest earned shall be allocated to the various funds in accordance with the allocation of investment earnings during the period of the advance. Each board, or the department if there is no board, may, by rule, assess and collect a one-time fee from each active and each voluntary inactive licensee in an amount necessary to eliminate a cash deficit or, if there is not a cash deficit, in an amount sufficient to maintain the financial integrity of such professions as required in this section. No more than one such assessment may be made in any 4-year period without specific legislative authorization. All monies collected by the department from fees or fines or from costs awarded to the department by a court shall be paid into the Professional Regulation Trust Fund, which fund is created in the department. The department may contract with public and private entities to receive and deposit revenue pursuant to this section. The legislature shall appropriate funds from this trust fund sufficient to carry out the provisions of this chapter and the provisions of law with respect to professions regulated by the department and any board within the department. The department shall maintain separate accounts in the Professional Regulation Trust Fund for every profession within the department. To the maximum extent possible, the department shall directly charge all expenses to the account of each regulated profession. For the purpose of this subsection, direct charge expenses shall include, but not be limited to, costs for investigations, examinations, and legal services. For expenses that cannot be charged directly, the department shall provide for the proportionate allocation among the accounts of expenses incurred by the department in the performance of its duties, with respect to each regulated profession. The department shall not expend funds from the account of a profession to pay for the expenses incurred on behalf of another profession. The department shall maintain adequate records to support its allocation of department expenses. The department shall provide any board with reasonable access to these records upon request. Each board shall be provided an annual report of revenue and direct and allocated expenses related to the operation of that profession. These reports and the department's adopted long-range plan shall be used by the board to determine the amount of license fees. A condensed version of this information, with the department's recommendations, shall be included in the annual report to the legislature, prepared pursuant to S. 455.2285. A condensed management report of budgets, finances, performance statistics, and recommendations shall be provided to each board at least once a quarter. The department shall identify and include in such presentations any changes or projected changes made to the board's budget since the last presentation. If a duplicate license is required or requested by the licensee, the board, or if there is no board, the department may charge a fee as determined by rule not to exceed $25 before issuance of the duplicate license. The department or the appropriate board shall charge a fee not to exceed $25 for the certification of a public record. The fee shall be determined by rule of the department. The department or the appropriate board shall assess a fee for duplication of a public record as provided in S. 119.07. The department or a board thereunder shall waive the initial licensing fee for a member of the armed services of the United States who has served on active duty, the spouse of a member of the armed services of the United States who is married to the member during a period of active duty, the surviving spouse of a member of the armed services of the United States who at the time of death was serving on active duty, or a low-income individual upon application by the individual in a format prescribed by the department. The application format must include the applicant's signature under penalty of perjury and supporting documentation as required by the department. For purposes of this subsection, the term low-income individual means a person whose household income before taxes is at or below 130% of the federal poverty guidelines prescribed for the family's household size by the United States Department of Health and Human Services, proof of which may be shown through enrollment in a state or federal public assistance program that requires participants to be at or below 130% of the federal poverty guidelines to qualify. The department or a board thereunder shall process an application for a fee waiver within 30 days of receiving it from the applicant. The department shall adopt rules necessary to implement the provisions of this subsection. 455.2.1. Legal and investigative services. 1. The department shall provide board counsel for boards within the department by contracting with the Department of Legal Affairs, by retaining private counsel, pursuant to S. 287.059, or by providing department staff counsel. The primary responsibility of board counsel shall be to represent the interests of the citizens of the state. A board shall provide for the periodic review and evaluation of the services provided by its board counsel. Fees and costs of such counsel shall be paid from the Professional Regulation Trust Fund, subject to the provisions of SS 215.37 and 455.219. All contracts for independent counsel shall provide for periodic review and evaluation by the board and the Department of Services provided. The Department of Business and Professional Regulation may employ or utilize the legal services of outside counsel and the investigative services of outside personnel. However, no attorney employed or used by the department shall prosecute a matter and provide legal services to the board with respect to the same matter. Any person retained by the department under contract to review materials, make site visits, or provide expert testimony regarding any complaint or application filed with the department relating to a profession under the jurisdiction of the department shall be considered an agent of the department in determining the state insurance, coverage and sovereign immunity protection applicability of SS 284, 284.3, 1 and 768.2, instruction on HIV and AIDS. 1. Under Chapter 477, shall require each person licensed or certified on human immune deficiency syndrome as part of biennial relicensure or relicensure on modes of transmission, infection control procedures, clinical management, and prevention of human immunodeficiency virus and acquired immune deficiency syndrome, with an emphasis on appropriate behavior and attitude change. When filing fees for each biennial renewal, each licensee shall submit confirmation of having completed said course on a form provided by the board or by the department if there is no board. At the time of the subsequent biennial renewal, when coursework is to be completed, if the licensee has not submitted confirmation which has been received and recorded by the board or department if there is no board, the department shall not renew the license. The board or the department where there is no board shall have the authority to approve additional, equivalent courses that may be used to satisfy the requirements in subsection. As of December 31st, 1992, the board or the department where there is no board shall require, as a condition of granting a license under any of the chapters or parts thereof specified in subsection, that an applicant making initial application for licensure complete an educational course acceptable to the board or the department where there is no board on human immunodeficiency virus and acquired immune deficiency syndrome. An applicant who has not taken a course at the time of licensure shall, upon an affidavit showing good cause, be allowed 6 months to complete this requirement. The board, or the department where there is no board, shall have the authority to adopt rules to carry out the provisions of this section. Any professional holding 2 or more licenses subject to the provisions of this section shall be permitted to show proof of having taken 1 board-approved course or 1 department-approved course where there is no board on human immunodeficiency virus and acquired immune deficiency syndrome for purposes of relicensure or recertification or additional licenses. 455.223 Power to administer oaths, take depositions, and issue subpoenas. For the purpose of any investigation or proceeding conducted by the department shall have the power to administer oaths, take depositions, make inspections when authorized by statute, issue subpoenas, which shall be supported by affidavit, serve subpoenas and other process, and compel the attendance of witnesses and the production of books, papers, documents, and other evidence. The department shall exercise this power on its own initiative, or whenever requested by a board or the probable cause panel of any board. Challenges to and enforcement of the subpoenas and orders shall be handled as provided in S 120.569, 455.2235 mediation. 1. Notwithstanding the provisions of S 455, the board, when there is no board, shall adopt rules to designate which violations of the applicable Professional Practice Act are appropriate for mediation. The board, or the department when there is no board, may designate as mediation offenses those complaints where harm caused by the licensee is economic in nature or can be remedied by the licensee. After the department determines a complaint is legally sufficient and the alleged violations are defined as mediation offenses, the department or any agent of the department may conduct informal mediation to resolve the complaint. If the complainant and the subject of the complaint agree to a resolution of a complaint within 14 days after contact by the mediator shall notify the department of the terms of the resolution. The department or board shall take no further action unless the complainant and the subject each fail to record with the department an acknowledgement of satisfaction of the terms of mediation within 60 days of the mediator's notification to the department. In the event the complainant and subject fail to reach settlement terms or to record the required acknowledgement, the department shall process the complaint according to the provisions of S 455.225. Conduct or statements made during mediation are inadmissible in any proceeding pursuant to S 455.225. Further, any information relating to the mediation of a case shall be subject to the confidentiality provisions of S 455.225. No licensee shall go through the mediation process more than 3 times without approval of the department. The department may consider the subject and dates of the earlier complaints in rendering its decision. Such decision shall not be considered a final agency action for purposes of Chapter 120. If any board fails to adopt rules designating which violations are appropriate for resolution by mediation by January 1st, 1995, the department shall have exclusive authority to and shall adopt rules to designate the violations which are appropriate for mediation. Any board created on or after January 1st, 1995 shall have 6 months to adopt rules designating which violations are appropriate for mediation, after which time the department shall have exclusive authority to adopt rules pursuant to this section. A board shall have continuing authority to amend its rules adopted pursuant to this section. All right. Authority to issue citations, notwithstanding S 455.225. The board or the department shall adopt rules to permit the issuance of citations. The citation shall be issued to the subject and shall contain the subject's name and address, the subject's license number if applicable, a brief factual statement, the sections of the law allegedly violated, and the penalty imposed. The citation must clearly state that the subject may choose, in lieu of accepting the citation, to follow the procedure under S 455.225. If the subject disputes the matter in the citation, the procedures set forth in S 455.225 must be followed. However, if the subject does not dispute the matter in the citation, with the department within 30 days after the citation is served. The citation becomes a final order and constitutes discipline. The penalty shall be a fine or other conditions as established by rule. The board or the department, when there is no board, shall adopt rules designating violations for which a citation may be issued. Such rules shall designate as citation violations those violations for which there is no substantial threat to the public health, safety, and welfare. The department shall be entitled to recover the cost of investigation, in addition to any penalty provided according to board or department rule, as part of the penalty levied pursuant to the citation. A citation must be issued within 6 months after the filing of the complaint that is the basis for the citation. Service of a citation may be made by personal service or certified mail. Restricted delivery to the subject at the subject's last known address. Within its jurisdiction, the department has exclusive authority to, and shall adopt rules to, designate those violations for which the licensee is subject to the issuance of a citation, and designate the penalties for those violations. If any board fails to incorporate this section into rules by January 1st, 1992, a board created on or after January 1st, 1992, has 6 months in which to enact rules designating violations and penalties appropriate for citation offenses. Failure to enact such rules gives the department exclusive authority to adopt rules as required for implementing this section. A board has continuous authority to amend its rules adopted pursuant to this section. 455.225 Disciplinary Proceedings. Disciplinary proceedings for each board shall be within the jurisdiction of the department. The department, for the boards under its jurisdiction, shall cause to be investigated any complaint that is filed before it if the complaint is in writing, signed by the complainant, and legally sufficient. A complaint is legally sufficient if it contains ultimate facts that show that a violation of this chapter of any of the practice acts relating to the professions regulated by the department, or of any rule adopted by the department or a regulatory board in the department has occurred. In order to determine legal sufficiency, the department may require supporting information or documentation. The department may investigate, and the department or the appropriate board may take appropriate final action on a complaint even though the original complainant withdraws it or otherwise indicates a desire not to cause the complaint to be investigated or prosecuted to completion. The department may investigate an anonymous complaint if the complaint is in writing and is legally sufficient, if the alleged violation of law or rules is substantial, and if the department has reason to believe, after preliminary inquiry, that the violations alleged in the complaint are true. The department may investigate a complaint made by a confidential informant if the complaint is legally sufficient, if the alleged violation of law or rule is substantial, and if the department has reason to believe, after preliminary inquiry, that the allegations of the complainant are true. The department may initiate an investigation if it has reasonable cause to believe that a licensee or a group of licensees has violated a Florida statute, a rule of the department, or a rule of a board. When an investigation of any subject is undertaken, the department shall promptly furnish to the subject or the subject's attorney a copy of the complaint or document that resulted in the initiation of the investigation. The subject may submit a written response to the information contained in such complaint or document within 20 days after service to the subject of the complaint or document. The subject's written response shall be considered by the probable cause panel. The right to respond does not prohibit the issuance of a summary emergency order if necessary to protect the public. However, if the secretary or the secretary's designee and the chair of the respective board or the chair of its probable cause panel agree in writing that such notification would be detrimental to the investigation, the department may withhold notification. The department may conduct an investigation without notification to any subject if the act under investigation is a criminal offense. The department shall allocate sufficient and adequately trained staff to expeditiously and thoroughly determine legal sufficiency and investigate all legally sufficient complaints. When its investigation is complete and legally sufficient, The department shall prepare and submit to the probable cause panel of the appropriate regulatory board the investigative report of the department. The report shall contain the investigative findings and the recommendations of the department concerning the existence of probable cause. At any time after legal sufficiency is found, the department may dismiss any case or any part thereof if the department determines that there is insufficient evidence to support the prosecution of allegations contained therein. The department shall provide a detailed report to the appropriate probable cause panel prior to dismissal of any case or part thereof, and to the subject of the complaint after dismissal of any case or part thereof under this section. For cases dismissed prior to a finding of probable cause, such report is confidential and exempt from S. 119.07. The probable cause panel shall have access, upon request, to the investigative files pertaining to a case prior to dismissal of such case. If the department dismisses a case, the probable cause panel may retain independent legal counsel, employ investigators, and continue the investigation and prosecution of the case as it deems necessary, as an alternative to the provisions of subsections. And, when a complaint is received, the department may provide a licensee with a notice of noncompliance for an initial offense of a minor violation. A violation is a minor violation if it does not demonstrate a serious inability to practice the profession, result in economic or physical harm to a person, or adversely affect the public health, safety, or welfare, or create a significant threat of such harm. Each board, or the department if there is no board, shall establish by rule those violations which are minor violations under this provision. Failure of a licensee to take action in correcting the violation within 15 days after notice may result in the institution of regular disciplinary proceedings. The department may issue a notice of noncompliance for an initial offense of a minor violation. Notwithstanding a board's failure to designate a particular minor violation by rule, as provided in paragraph, the determination as to whether probable cause exists shall be made by majority vote of a probable cause panel of the board or by the department, as appropriate. Each regulatory board shall provide by rule that the determination of probable cause shall be made by a panel of its members, or by the department. Each board may provide by rule for multiple probable cause panels composed of at least 2 members. Each board may provide by rule that one or more members of the panel or panels may be a former board member. The length of term or repetition of service of any such former board member on a probable cause panel may vary according to the direction of the board when authorized by board rule. Any probable cause panel must include one of the board's former or present consumer members, if one is available, willing to serve, and is authorized to do so by the board chair. Any probable cause panel must include a present board member. Any probable cause panel must include a former or present professional board member. However, any former professional board member serving on the probable cause panel must hold an active valid license for that profession. All proceedings of the panel are exempt from S. 286.01 until 10 days after probable cause has been found to exist by the panel, or until the subject of the investigation waives his or her privilege of confidentiality. The probable cause panel may make a reasonable request, and upon such request, the department shall provide such additional investigative information as is necessary to the determination of probable cause. A request for additional investigative information shall be made within 15 days from the date of receipt by the probable cause panel of the investigative report of the department. The probable cause panel or the department, as may be appropriate, shall make its determination of probable cause within 30 days after receipt by it of the final investigative report of the department. The secretary may grant extensions of the 15-day and the 30-day time limits. In lieu of a finding of probable cause, the probable cause panel, or the department when there is no board, may issue a letter of guidance to the subject. If, within the 30-day time limit, as may be extended, the probable cause panel does not make a determination regarding the existence of probable cause, or does not issue a letter of guidance in lieu of a finding of probable cause, the department, for disciplinary cases under its jurisdiction, must make a determination regarding the existence of probable cause within 10 days after the expiration of the time limit. If the probable cause panel finds that probable cause exists, it shall direct the department to file a formal complaint against the licensee. The department shall follow the directions of the probable cause panel regarding the filing of a formal complaint. If directed to do so, the department shall file a formal complaint against the subject of the investigation and prosecute that complaint pursuant to Chapter 120. However, the department may decide not to prosecute the complaint if it finds that probable cause had been improvidently found by the panel. In such cases, the department shall refer the matter to the board. The board may then file a formal complaint and prosecute the complaint pursuant to Chapter 120. The department shall also refer to the board any investigation or disciplinary proceeding not before the Division of Administrative Hearings pursuant to Chapter 120 or otherwise completed by the department within 1 year after the filing of a complaint. The department, for disciplinary cases under its jurisdiction, must establish a uniform reporting system to quarterly refer to each board the status of any investigation or disciplinary proceeding that is not before the Division of Administrative Hearings or otherwise completed by the department within 1 year after the filing of the complaint. A probable cause panel or a board may retain independent legal counsel, employ investigators, and continue the investigation as it deems necessary. All costs thereof shall be paid from the Professional Regulation Trust Fund. All proceedings of the probable cause panel are exempt from S 120.525. A formal hearing before an administrative law judge from the Division of Administrative Hearings shall be held pursuant to Chapter 120 if there are any disputed issues of material fact. The administrative law judge shall issue a recommended order pursuant to Chapter 120. If any party raises an issue of disputed fact during an informal hearing, the hearing shall be terminated, and a formal hearing pursuant to Chapter 120 shall be held. The appropriate board, with those members of the panel, if any, who reviewed the investigation pursuant to subsection being excused, or the department when there is no board, shall determine and issue the final order in each disciplinary case. Such order shall constitute final agency action. Any consent order or agreed settlement shall be subject to the approval of the department. The department shall have standing to seek judicial review of any final order of the board, pursuant to S 120.68. Any proceeding for the purpose of summary suspension of a license, or for the restriction of the license, of a licensee pursuant to S 120.60 shall be conducted by the Secretary of Business and Professional Regulation or his or her designee, who shall issue the final summary order. The department shall periodically notify the person who filed the complaint of the status of the investigation, whether probable cause has been found, and the status of any civil action or administrative proceeding or appeal. The complaint and all information obtained pursuant to the investigation by the department are confidential and exempt from S 119.07 until 10 days after probable cause has been found to exist by the probable cause panel or by the department, or until the regulated professional or subject of the investigation waives his or her privilege of confidentiality, whichever occurs first. However, this exemption does not apply to actions against unlicensed persons pursuant to S 455.228 or the Applicable Practice Act. Upon completion of the investigation and pursuant to a written request by the subject, the department shall provide the subject an opportunity to inspect the investigative file, or, at the subject's expense, forward to the subject a copy of the investigative file. The subject may file a written response to the information contained in the investigative file. Such response must be filed within 20 days, unless an extension of time has been granted by the department. This subsection does not prohibit the department from providing such information to any law enforcement agency or to any other regulatory agency. A privilege against civil liability is hereby granted to any complainant or any witness with regard to information furnished with respect to any investigation or proceeding pursuant to this section, unless the complainant or witness acted in bad faith or with malice in providing such information.